We are proceeding today by video conference. First, let me ask the attorneys place their appearance on the record, beginning with Mr. McCready.
Good morning, Your Honor. Dave McCready for the people.
Stand silent on behalf of Mr. Highland.
All right, and Mr. Solid, where do we stand with Mr. Highland's case today?
At this point in time, I think Mr. McCready and I are asking for an adjournment. There is, this is the case where there's some 20,000 pages of Facebook messaging that he and I are both trying to feather through and potentially could be evidence in the case. And there may be motions on that as well, if in fact some of those are going to be used.
Mr. McCready?
Yeah, that is correct. There, the Sheriff's Department did several subpoenas of records from Facebook. One of them is 20,000 pages long. Between the 5 accounts that we got back, it's actually more, it's closer to 100,000 pages of Facebook records. So yes, if we could adjourn this just for the parties to work our way through those a little bit better, we might be able to come to a resolution.
How long do you anticipate needing in order to do that?
I think a month would be sufficient for me.
That's fine, Your Honor. I have no objection.
About June 26th, then at 10, or I'm sorry, at 8:15.
It's time for the people.
I actually have a conflict on that day, Your Honor. I'm in Jackson.
Are you sure, Stan? That we talked about that one yesterday.
That Bishop motion is at 8:15. I have to be in Jackson at 10:30. So
Oh, I see.
All right, so then we'd be looking at July 17th.
that'll work for me.
That's fine.
So July 17th at 8:15. Mr. McCready, would you do a stipulation in order for that adjournment?
I can. Yes, sir.
Well, you're right, Mr. McCready. That case may be adjourned, but this is a better date anyway. July 17th gives me a little more time to go over everything. All right, I appreciate it. Thank you, Your Honor.
Thank you, Your Honor.
Okay, thank you. Ms. Underwood, I have Ms. Page here. Do you need to speak to her?
I'm sorry, Your Honor.
I have Ms. Page here. Do you need to speak to her?
Yes, thank you.
All right, Ms. Page, can you hear me?
Yes, I can.
All right, I'm going to put you in a breakout session with Ms. Underwood.
Okay.
Mr. Glazer, I have Alex Peck logged in. You need to speak to him.
Yeah, I didn't know you were gonna do him first. He's here. I'll bring him back into my office here. I need to talk with him a little bit. I've got a couple other I could do though.
Okay, we're calling the jail for Mr. Kennedy right now.
Okay, and then
I didn't realize Mr. Peck was in your office, so just let me know when you're ready for him.
Yeah, I'll have him come back.
Okay.
Could we put Dan Kennedy for the judge, please? Kennedy. Thank you. Thank you. Bye.
Pat?
Yeah, because,
Okay. All right.
so
Okay, Ms. Underwood, are you ready to proceed with Ms. Page?
We are, Your Honor. Thank you.
All right, we're on the record then in file 23-21372. People versus Amber Lane Page. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. Brenner.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Rhonda Underwood for Ms. Page this morning.
All right, and where do we stand with Ms. Page's case today, Ms. Underwood?
Your Honor, this case has been around for a while, and we are happy to say we are going to resolve it today. Ms. Page will be pleading guilty as charged with no subs, Your Honor, and the prosecutor will agree to no upfront jail and probation if she's paying between now and sentencing, Your Honor.
That's correct, Your Honor. If she's paying as ordered between now and
Yes,
sentencing,
as
which has been a struggle, and we've been adjourning things out to give her chances, and so she's paying sporadically. So if she's paying as ordered between now and sentencing, no upfront jail.
Okay, Ms. Page, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
And you are Amber Lane Page, correct? Ms. Page, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, failing to pay child support?
Correct.
Do you understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $2,000 fine?
Yes, I understand.
Other than, as we've discussed it on the record here today, neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Brenner?
That's correct, Your Honor.
Ms. Underwood?
That's correct, Your Honor.
Is that also your understanding, Ms. Page?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have a right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to have the witnesses against you appear at your trial, to ask those witnesses questions, and to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Ms. Page, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes.
If you are not a citizen of the United States of America, a conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about April 1st, 2022 through January 31st, 2023 in the city of Adrian, County of Lenawee, that you did commit the offense of failing to pay child support?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to court on the record this morning, or that it was not your own choice to enter the plea?
I'm sorry, can you repeat that one more time?
Do you understand that if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Ms. Page to plead guilty?
No, Your Honor.
No, Your Honor.
Ms. Page, other than as we've discussed it on the record this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty today?
Yes.
Ms. Underwood, do you want to establish the factual basis?
Thank you, Your Honor. Ms. Page, are you Amber Elaine Page?
Yes.
And do you have a child support order in the 39th Circuit Court, Lenawee County, state of Michigan?
Yes.
And do you reside in that county, in this county?
I do.
And during the month of 4/1/22 to 1/31/23, is it true that you did not pay your child support order as ordered?
That is correct.
I believe I've established the factual basis.
And Ms. Page, since then, at the time this charge was issued, you owed just over $7,400. Now it's grown to just over $9,400. Is that accurate?
Yes, that is accurate.
People are satisfied, Your Honor.
All right, has the court complied with MCR 6.302 B, C, and D, Ms. Brenner?
Yes, Your Honor.
Ms.
It
Underwood?
has, Your Honor.
I will accept the plea then. It's been given understandably, voluntarily, and accurately. Ms. Page has had full knowledge of her rights and she has had competent counsel. The court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as we've discussed it on the record here this morning. I am referring this matter to the probation department.
Your Honor, could we have a sentencing, I'm sorry to interrupt. Could we have a sentencing date some 60 days out? Please, Your
No,
Honor.
no objection to that, Judge.
Okay, so we'd be looking at toward the end of July then. How about July 25th at 8:15?
Thank you very much, Your Honor.
That's fine, Judge.
Okay, so July 25th at 8:15. Ms. Page, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Okay.
Your Honor, could I get Ms. Page's address and phone number?
I will put you in a breakout session with Ms.
Thank you,
Page
Judge.
and get that from her.
Okay.
All right, Ms. Underwood, I also have Mr. Moreno here. Do you need a breakout session with him?
Just very briefly, Your Honor.
All right, as soon as he pops up, I will do that for you. All right, Mr. Moreno, can you hear me? Are you there? Are you there, Mr. Moreno?
I am.
Okay, I'm going to put you in a breakout session with Ms. Underwood, if you give me just a moment.
Okay.
Mr. Murphy, are you there?
Yes, Your Honor.
Do you need a breakout session with Mr. Underwood?
If I could, please, Your Honor.
Okay, give me 1 second to bring him over. Mr. Underwood, are you there?
Yes, sir.
Okay, I'm going to put you in a breakout session with Mr. Murphy.
Okay.
All right, Ms. Page, if you are done giving your address to the probation department, you can go ahead and log out. Okay, we are on the record now in file 24-21714-FH, People versus Jesus Joseph Moreno. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me have the attorneys place their appearances on the record, beginning with Ms. Brenner.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Ron Underwood for Mr. Moreno this morning, Your Honor.
All right, and where do we stand with Mr. Moreno's case today?
Your Honor, Mr. Moreno is accumulating a good history of payment. We would ask and I've discussed this with the prosecutor, I believe we would like an adjournment, possibly till August, Your Honor, to give Mr. Moreno more time to establish this good history.
And I don't have an objection to that, Judge. He is making good progress.
Okay. August, I can do August 14th at 8:15.
Sounds good, Judge.
And I will do this stipulation in order, Your Honor, with Ms. Brunner's permission.
Yes, thank you, Rhonda.
Okay, so I also see we've got a note in the file that we don't have prints for Mr. Moreno yet, so I'm going to do an order for fingerprints.
Okay.
So Mr. Moreno, when you get a copy of that order, you're going to need to go to the City of Adrian Police Department to get your fingerprints done. You should call them and set up, find out what time they want you to show up to do that, because they think they try to limit that to specific dates and times.
Okay, is there any way that I could get that done here where I'm local?
I don't know if a local agency will do it and transmit that information to us or not. My experience is that they usually don't. So you should do it at the City of Adrian Police Department. They do it at 7:30 on Monday through Thursday.
Okay, I'm currently fighting an OVI case. My driving is limited. That's why I'm in the process of getting that fixed right now.
All right, well, it's got to be done before the case can be resolved. So you're going to have to find a ride or do something.
Okay, okay.
Okay, so you can go ahead and log out.
All right, thank you.
Thank you, Honor.
Okay, let's see, Mr. Glazer, are you ready with Mr. Peck then?
Yes, I am, Your Honor.
All right, we are on record in files 24-21732-FH. I'm sorry, it's just that one file. We are here today for a pretrial conference as well as pretrial on a contempt of court. We are proceeding today by a video conference. First, going to have the attorneys place their appearances on the record. We have a prosecutor that's handling Mr. Peck's case.
But we should have Mr. Sneed. I can cover if it's not complicated.
Why don't we try that? I guess, Mr. Glazer, you want to place your
Excuse me, Your Honor, I couldn't hear you or understand you.
Can you place your appearance on the record?
Yeah, John Glazer on behalf of the defendant, Your Honor.
And Allison Arnold for the people.
Thank you. And where are we with Mr. Peck's case today?
Your Honor, it's my client's going to take a plea, but there needs to be an amended information filed. He was offered plea to the carrying a concealed weapon, plea to an added count of use of cocaine, and then there would also be a charge of city resisting and opposing, which is a misdemeanor. He would plead to those three, and then all the remaining counts would be dismissed. And they would have no objection to Home Youthful Trainee Act He is 21 at this time. And I don't know how old you were at the time. He was 21 back then. Yeah, he was 21 at the time this happened.
All right, I'm gonna need, yeah.
We don't have that paperwork prepared. So if we can, I don't know if the court wants to try to call it towards the end of the docket, and I'll try to get it done. If I can take a break or someone can sub in, we can try to get that paperwork done, or if we want to adjourn it a week and do it in a week.
I'd rather not adjourn it, Your Honor. He comes down from Mason. He's not local here.
All right,
We don't have a problem putting it off for a while to get that done.
Yeah, Judge, if we can call that a little bit later, I can have someone get the paperwork ready, and then we can recall it when the paperwork's ready.
All right, I'll pass it for now then.
Yeah, we'll do a written plea agreement, and I can email it to Mr. Glazier. He and his client can electronically sign it and email it back to the court, and we'll get an amended information.
Okay, you did, the trickiest part was that resisting and opposing is gonna be a city. Resisting and opposing, so Isaac told me.
Yeah, I'm not sure if we can't do that in this plea form. So,
No, but, well, you can do it in circuit court. I mean, you can plead to misdemeanors there, but however you want to do it, that's what the intent is.
okay, all right, we'll figure it out.
You know, if you, to make it easier, if you wanted to do it just as a state disorderly, we could do that. That'd be the same thing. It'd be 93, and then you wouldn't be adding a city charge onto the information.
Okay, I'll track down Mr. Sneed and we'll figure that out.
All right, Your Honor. I'll put my client be out in the waiting room when we're ready to do this.
Okay, that sounds good.
Right. Have a seat out there, and then it's going to take a while, but it's better than coming back.
Yeah, that's fine. That's fine. All right.
All right, I have a Lenawee jail Zoom device logged in. The microphone is muted and the camera is off. If there's someone there in the Zoom pod, I need you to turn the camera on and unmute the microphone. Okay, while we try to resolve that issue, Mr. Murphy, are you ready to proceed with Mr. Underwood?
Yes, Your Honor.
All right, this is file 24-21704-FH, People versus Eric Underwood. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with, this looks like Mr. Bayonetto's case.
Judge, I'm here on the case.
Oh, I'm sorry. Go ahead then.
Allison Arnold for the people.
Matthew Murphy, appearing on behalf of Mr. Underwood.
All right, Mr. Murphy, where are we with Mr. Underwood's case?
Your Honor, at this time, Mr. Underwood wants to set trial on this matter, a jury trial on this matter. I believe it might take 2 days, Your Honor.
All right. You agree with 2-day time frame, Ms. Arnold?
Judge, I think we're gonna file a 404B notice. And I don't know if it qualifies under 768.27. So if additional evidence comes in, we may need 3 days.
Okay, so Francis, could you find us 3 days for a jury trial, please?
Yes. Tuesday, October 29th at 9 a.m., October 30th at 10:30, and October 31st at 9 a.m.
Yes, Your Honor, that works for the defense.
That should be fine, Judge.
All right, so October 29th. Let's do a final pretrial on October 16th, if that works.
Yes, Your Honor. Thank you.
That should be fine.
All right, so final pretrial on October 16th, trial on the 29th, 30th, 31st. Court will issue a scheduling order. Is there anything else we need to address with this case today?
No, thank you.
No, Your Honor. Thank you.
Okay, thank you then, Mr. Underwood. You are set for today. You can go ahead and log out.
Thank you, sir.
Thanks, Mr. Underwood. I'll be in contact with you, okay?
Yes, sir. Thank you very much.
Okay, the gentleman at the jail, you're Mr. Kennedy? I was not able to hear you, sir. Mr. Kennedy, can you hear me? Can you try sitting closer to the device and speaking louder? I'm not able to hear anything that you're saying. Okay, Mr. Ryan, are you there? Mr. Ryan, can you hear me? Are you there, Mr. Ryan? Mr. Ryan, are you able to hear me? Can you say something, please? Or Mr. Ryan, if you're saying anything, I'm not able to hear you. Mr. Ryan, if you can hear me, please leave the meeting, log out, and then log back in, and we'll see if that fixes your audio problem, because I can't hear anything if you're saying anything. All right, for the officer at the jail, are you able to hear me? Okay, I'm not able to hear anything that you're saying. All right, can I have Ms. Ungst and Mr. Goodlow come forward, please? Ms. Ungst, you'll sit at this table here. Oh, Mr. Goodlow was here, but he's left, so we're gonna have to wait on that. Okay, Mr. Goodlow, you wanna come forward and sit at the table here? This is file 23-51145-PP. Ashley Nicole Ungst versus Daryl Denard Goodlow Sr. We are here today for a hearing on an order to show cause relative to an alleged violation of a personal protection order. Sir, you are Daryl Denard Goodlow Sr., is that correct? Yes, Mr. Goodlow, have you received a copy of the order to show cause?
Yes, sir.
And before the court today on that order to show cause, it alleges that you violated the personal protection order by confronting Ms. Ungst in the parking lot after the last hearing in this case. The maximum possible penalty for violation of the personal protection order is up to 93 days in jail and or a $500 fine. You do have the right to be represented by an attorney at this hearing today and at any other hearings that we might have on this matter. If you can't afford an attorney, you can tell me that and I will appoint one for you at public expense. Do you understand all of that? Yes, sir. Do you want to be represented by an attorney? Yes, sir. Do you understand that you have a right to contest the violation of personal protection order charge and to have a trial? Yes, sir. You understand that throughout that trial, you'd be presumed innocent until your guilt is proven beyond a reasonable doubt. Yes, sir. You have the right to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions. You also have the right to have me order any witnesses you have for your defense to appear at your trial. Do you understand all of that? Yes, sir. You're not required to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that? On the other hand, you have the right to testify at the trial if you wanted to testify. Do you understand that as well? Yes, sir. How do you want to plead to the charge that you violated the personal protection order? Not guilty. All right, so I'll enter a not guilty plea for Mr. Goodlow, and we'll set this for a trial. Francis, could you find us, we're probably going to need about an hour for a trial in this case.
June 4th at 9 a.m.
Set the trial for June 4th at 9 a.m. Court will issue a scheduling order and mail it to both of you. Okay. Thank you.
Thank you.
We have the jail Zoom device again. Are you able to hear me there? All right, can you try saying something? Because I still don't hear any audio from the jail. I can't hear anything. All right, I don't know here. I see motions, but I don't hear anything. I'm getting no audio from that jail device. I cannot hear you. So I presume it looks like you're taking him to another room. Is there a Mr. Forkey or a Mr. Spore here? Michael or Lene Forkey or Daniel Spore? This is file 24-51620-PP. Michael Forkey is next friend of Lene Forkey versus Daniel Spore. Today's date time set for a hearing on an order to show cause that was entered by the court on April 30, 2024. Setting a hearing for today at 8:15 a.m. Neither of the petitioner nor the respondent have appeared, and I would also note that the order to show cause does not appear to have been served. In this case, there's no proof of service indicating that was done. All right, Mr. Ryan, are you there?
Yes.
Okay, Mr. Ryan, I'm going to put you in a breakout session with Ms. Underwood if you give me just a moment.
Okay, thank you.
Okay, Mr. Kennedy, can you hear me?
Yeah.
Okay. All right, so it looks like Mr. Daly has the 23 cases and Mr. Glazer has the 24 case. Do you want me to put you all in a breakout session together?
Is it Mr. Daly or Miss?
Your
Hennig?
Honor, yeah, I have Mr. King's cases with Mr. Glacier.
Oh, I'm sorry.
And I would leave it to my client as to whether he wants to go into a breakout, because we did have a meeting last week. And I think that we're all on the same page.
I probably should talk to him. I don't know if Miss Hennigan wants to be part of that or not.
You can go ahead, Mr. Glacier. I'll just wait.
All right.
I'm sorry, I clicked the wrong button. Sorry, Ms. Underwood, I'll put you back in a breakout session with Mr. Ryan in just a moment.
Oh, we're fine, Your Honor.
Okay. All right, sorry, Mr. Glazer, I clicked the wrong button, so let me set that up once more. Are you ready to proceed with Mr. Ryan then?
I am, Your Honor.
All right, this is file 24-21670-FH, People versus Davian Scott Ryan. We are here today for pretrial conference in the case. We are proceeding today by video conference. First, let me have the attorneys place their appearances on the record, beginning with Ms. Arnold for the plaintiff. People.
Allison Arnold for the people.
Rhonda Underwood for Mr. Ryan, Your Honor.
All right, and where are we with Mr. Ryan's case today?
Your Honor, Mr. Ryan will be pleading as charged, Your Honor, to count one and no supplements, and there is a Kilbrew to a Haida, Your Honor, in this matter.
Judge, I'm gonna have to clarify that offer with Mr. Bayonetto, because my notes say as charged with Haida. It doesn't say anything about dropping the subs. So I need to
I don't show any subs on the information.
Yeah, I thought it would be weird that we would have subs and we would offer Haida.
No. There are no.
There are no supplements on the information.
Okay, hang on one second too. Just one second. I want to get the information pulled up because there's not a written plea agreement in the file. Sorry, we're trying to get new laptops because these are not very functional. It says as charged, so that would be count 1 and count 2 with the recommendation of FIDA. I believe Ms. Underwood said just count 1.
I'm sorry, I thought it was count 1.
So do you want to talk to Mr. Ryan again, or what do you want to do?
Just briefly, Your Honor.
All right, Mr. Glazer, you ready to proceed with Mr. Kennedy?
Yes, I am, Your Honor.
Okay. We are on the record in files 23-21426-FH, 23-21427-FH, 23-21578-FH, and 24-21803-FH. People versus Daniel Martez Kennedy. We're here today for pretrial conferences in all of those cases. We are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
John Glazier on behalf of Mr. Kennedy on file 24-21803FH.
Maris Hennigan on behalf of Mr. Kennedy on all the remaining files.
Right, and so where do we stand with Mr. Kennedy's cases today? I guess I'll ask Mr. Glazier first, since you've got Ms. Hennigan first, because she's got the older cases.
Your Honor, I believe that we've reached a global settlement on these cases, and Mr. Kennedy has had the opportunity to speak with both of his attorneys about this and is prepared to enter a plea today.
Okay, is that correct, Mr. Glazier?
That's correct, Your Honor.
Okay, so Ms. Hennigan, do you want to tell me what the plea is then?
Judge, this plea agreement is very complicated. He's pleading to 1, 2, 3, 4, 5, 6, 7 counts, HO subs. We're dismissing several counts. It's got a sentence recommendation. I do have a written plea agreement. I know we're trying to get the defense counsel in the habit of having a signed plea agreement so everyone understands what the agreement is. I could email the agreement if
I've got the agreement. I went over.
Have it. Thank you.
And he was supposed to send me an amended one, which I've never gotten. Habit or not, that's the facts of life. Mr. Sneed sent it to me back on May 1st. I called him on May the 2nd. He told me he'd send me a new one because mine was not accurate. Count 3 was not supposed to be on there. That was supposed to be dismissed and everything was to run concurrent with Ms. Hennigan's. But I've never gotten the amended plea agreement, and so it's not like we're not doing it. And trying to get us in the habit of something means you got to get in the habit of doing something as well.
Right, and I wasn't trying to cast any aspersions against defense counsel. I just feel like it's a complicated plea agreement and we should have a signed copy. But I do not have an amended plea offer in the file, and there are no notes by Mr. Sneed okaying an amended plea agreement. I think he might be doing Judge Anzalone's docket. I can try to get in touch with him and see if we can modify that. And the agreement does say all files to run concurrently, but Mr. Glazier, you're saying dismiss count 3 and the 24 file was supposed to be part of the deal?
What the part of the deal was original offer was he was gonna plead to 2 counts, no sup, and it would run concurrent.
Okay, that's not what this is. This has 3 counts and the subs.
I have that, I realized that, and I talked to Mr. Sneed, and he said he was gonna resend me a new plea agreement, which I've never received. That was back on May 2nd when he told me that.
Okay. Judge, we can try to adjourn it for a week, or I can see if I can get in touch with Mr. Sneed. I believe he's doing Judge Ansel and Stockett, and see if we can get an amended agreement. If that in fact is the agreement.
All right, I will let this go then till the end of the call, and we'll see where we stand with whether or not we have what we need at that time.
Okay.
So Mr. Kennedy, you can let them know that you are done with court for right now, but we may call you back in a little bit. Can you call for Mr. Ms.
Kelly and Judge Seegers. Could we have Larry Clark in the room for the judge, please? Thank you. Bye.
Okay, Mr. Dagger Margosi, are you there?
Yes, Your Honor.
Is there a Katrisa Edwards in the court? All right, so this is file 24-21766-FH People versus Katrisa Pearl Edwards. We are here today for a pretrial conference in this case, and we're proceeding today by video conference. Do we have a prosecutor that is handling this one?
Judge, I'm here on that one too.
You want to place your appearance on the record?
Allison Arnold for the people.
Your Honor, Michael Dagmar-Gosian for, but not with Miss Edwards.
All right. Sir, here. Apparently Ms. Edwards is here. Mr. Dagmar-Gosian, you need to speak to her.
I probably do. I was not able to contact her, but if she has her phone with her, I can give her a call if she steps out into the hallway.
You don't have her phone with her. All right. Can you step out in the hallway, Sergio, and turn the iPad on? We'll turn the iPad on out in the hallway and have you speak to her that way. Mr. Malero, I have Mr. Dickerson here. Do you need a breakout session with him?
Yeah, Judge, that'd be fine.
Give me just a second. All right, Mr. Dickerson, I need you to unmute your device.
Yes.
Okay, I'm going to put you in a breakout session with Mr. Malaro.
All right, thank you.
Ms. Underwood, are you ready to proceed with Mr. Ryan?
Yes, Your Honor.
All right, we're back on the record in file 24-21670-FH. Ms. Underwood has had another chance to speak to Mr. Ryan, do you know how Mr. Ryan wants to proceed today?
Your Honor, Mr. Ryan, I've discussed the difference with him. Mr. Ryan wishes to enter the plea, Your Honor.
Okay, so that would be a plea to both counts, 1 and 2.
Yes, Your Honor.
And I'm sorry, what?
There's an agreement between the parties. He'll be sentenced under the Holmes Youthful Trainee Act.
Okay. All right, Mr. Ryan, I need you to hold your device so I can see you. Will you raise your right hand, please? All right, Mr. Ryan, I need you to go put a shirt on.
Okay. Sorry.
All right, for future reference, Mr. Ryan, appearing in court by Zoom is the same as if you were here in person in the courtroom. And I expect you to be dressed appropriately and behave just as though you were sitting in the courtroom in person.
Okay.
Swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury.
I do.
You are Davian Scott Ryan.
Yes, sir.
Mr. Ryan, you've heard the statement of your attorney and the prosecuting attorney is that your intention to plead guilty to count 1, stealing or retaining a financial transaction device without consent.
Yes.
Do you understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $5,000 fine?
Yes.
It's also your intention to plead guilty to count 2, which is illegal sale or use of a financial transaction device.
Yes.
Do you understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $5,000 fine?
Yes.
Are you satisfied with Ms. Underwood and the advice that she's given you?
Yes.
Other than as we've discussed it on the record here today, neither the prosecutor, defendant, defense attorney, or anyone acting on behalf of any of them has discussed a possible sentence with the court. Is that correct, Ms. Arnold?
Correct, Your Honor.
Ms. Underwood?
Yes, Your Honor.
Is that also your understanding, Mr. Ryan?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You can ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Ryan, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
Do you also understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
Do you understand that you're giving those rights up?
Yes.
how do you wish to plead to the charge that on or about October 25th, 2023, in the city of Adrian, county of Lenawee, that you did commit the offense of stealing or retaining a financial transaction device without consent?
Guilty.
And how do you wish to plead to the charge that on or about October 25th, 2023, in the city of Adrian, county of Lenawee, that you did commit the offense of illegal sale or use of a financial transaction device?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No.
Do you understand that if I accept your plea, you will be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
I do.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than plea bargain to induce Mr. Ryan to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Ryan, has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've discussed it on the record?
No.
Is it your own choice to plead guilty?
Yes.
Ms. Underwood, do you want to establish a factual basis?
Thank you, Your Honor. Mr. Ryan, on October 25th, 2023, you were in the city of Adrian, county of Lenawee, state of Michigan.
Yes.
And at that time, did you come to possess a financial transaction device, a gas card owned by Skarsky Excavating?
Yes.
And you no longer had any right to have that card, correct?
No.
You had it without their permission.
Yes.
And you proceeded to use that card to buy gas for yourself and other people, correct?
Yep. Mm-hmm.
I believe I've established count 1 and count 2.
Ms. Arnold, are the people satisfied?
We are.
Has the court complied with MCR 6.302 B, C, and D, Ms. Arnold?
Yes, Your Honor.
Ms. Underwood?
Yes, Your Honor.
All right, I'll accept the pleas. They've been given understandably, voluntarily, and accurately. Mr. Ryan has had full knowledge of his rights, and he's had competent counsel. The court's not made any agreement regarding the possibility of a plea or sentence in the case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, except as we've discussed on the record here this morning. I will refer this matter to the probation department and set sentencing for June 27th at 8:15 a.m.
June 27th.
Your Honor, creating a breakout room to get his address.
I will set up that breakout room in just a moment. So sentencing again is June 27th at 8:15 a.m. I am going to require at this point that that be conducted in person. Mr.
Okay.
Ryan, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Okay.
I'm going to put you in a breakout session right now so that you can give your contact information to the probation department.
Okay.
All right, Ms. Underwood, Mr. Collar is here in the courtroom.
Thank you, Your Honor. I will be right down.
All right, Mr. Dagger Margosian, are you ready to proceed with Ms. Edwards?
Yes, Your Honor, thank you.
Ms. Edwards. You are on the record in file 24-21766-FH. People versus Cateresa Pearl Edwards. We are here today for a pretrial conference in this case, as well as an appearance on the board of show cause relative to a failure to appear on May 1st. First, can I have the attorneys place their appearance on the record, beginning with Ms. Arnold?
Allison Arnold for the people.
Your Honor, Michael Dagger Margosian for Miss Edwards.
All right, and Miss, you are Cateresa Pearl Edwards?
Yes, Cateresa.
Cateresa, I'm sorry. Ms. Edwards, have you received a copy of the order to show cause?
Yeah.
Okay. That order to show cause alleges that you failed to appear at a pretrial conference in this case on May 1st, 2024. If true, that would be a contempt of court. The maximum penalty for a contempt of court is up to 93 days in jail or $7,500. You have the right to be represented by an attorney. With respect to that issue, you are represented by the Public Defender's Office with respect to the underlying issue. So if you like, I'll appoint Mr. Dagger Margosian to represent you with respect to contempt as well. Is that what you'd like?
Oh, can you repeat that?
You have the right to an attorney to represent you with respect to the contempt that I just told you about. If you can't afford an attorney, I'll appoint one for you at public expense. Do you want an attorney to represent you with respect to the contempt?
Yes.
Okay. Do you have the ability to pay for your own?
Yeah.
Okay. I'll appoint Mr. Dagger Margosian to represent you with respect to that, as he already represents you with respect to the underlying case. Mr. Dagger Margosian, do you know how Ms. Edwards wants to proceed?
Your Honor, on the underlying case or on the show, I'm happy to address the court on the show cause first, if that's fine.
Go ahead.
Your Honor, my understanding of what occurred on May 1st is, first of all, it was Ms. Edwards, her first appearance in circuit court. She had appeared for everything in district court. There was, on belief and information, it was an error on her part by setting her alarm for PM rather than AM. It was not done on purpose. She has, in addition to that, she's gotten a new phone number, which is why I wasn't able to contact her. Now that those issues are resolved, this won't happen again. It wasn't done intentionally. I'd ask the court to take that into consideration.
I'll enter a not guilty plea for the time being on that. Do you know how she wants to proceed on the underlying case?
Your Honor, on the underlying case, we held a preliminary exam. We do have the transcript of that hearing. I anticipate that I'll be filing a motion to quash. So what I would ask is one of two things: either schedule this matter for a jury trial a ways out to give both parties an opportunity to file and be heard on the motion to quash, or to schedule this for a pretrial with the intention of scheduling the motion to quash in between now and then.
All right, Ms. Arnold, do people have anything that we need to address today?
No, thank you, Your Honor.
Your Honor, the only other thing I'll add is that this case was originally assigned to Mr. Fleming. He is no longer at their office now that it is with Ms. Arnold. She may have a different view on the case. Mr. Fleming and I did not see eye to eye, but I'm happy to talk with Ms. Arnold regarding this case to see if there is any resolution possible.
Ms. McClure is going to be handling the case. She's in Judge Ancelone's court right now, but I know we have not made an offer to the defense for a new offer anyways. I don't know if Mr. Fleming made an offer. So I think a pretrial would be appropriate rather than setting a trial date at this time.
All right, Mr. Dagger Margosian, did you say that you had already ordered the transcript?
We've ordered, we received it yesterday, so we have what we
All right.
need.
Okay, I just want to make sure there wasn't anything else to do there. So let's go with July 24th at 8:15 for a pretrial conference.
It's fine, thank you.
Okay, and Mr. Dagger Margosi, can you prepare that stipulation in order?
I will, Your Honor, thank you.
Okay, so Ms. Edwards, your next date is July 24th at 8:15 a.m.
Okay,
All right.
Thank
You're all
you.
set for today.
thank you.
Thank you. Mr. Glazer, do you need a breakout session with Mr. Clark?
Yes, I do.
1 second. See if the Jim's in the mood. What we could do. Mr. Millar, are you ready to proceed with Mr. Dickerson?
I am, Your Honor.
We're on the record in file 24-21739-FH, People versus Sean Davis Dickerson. We are here today for a pretrial conference in this case. We are proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. Arnold.
Ellison Arnold for the people.
Salvatore Malero on behalf of Sean Dickerson.
Okay, Mr. Malero, where do we stand with Mr. Dickerson's cases today, or case today?
Judge, I'm going to ask to adjourn this one more time. We're still looking into some things and doing some investigation on some of these issues. And I think if we don't get it resolved, by then we would be ready to set it for trial.
Ms. Arnold, anything to address from the people's side?
No, thank you, Your Honor.
I'm sorry, how far out did you want to look, Mr. Malero?
Like 30, 45 days should be good.
How about June 26th?
That'd be good, Judge.
Just gonna make sure Ms. McClure is gonna be here that date. That looks good.
Okay, so June 26th at 8:15. Mr. Malaro, would you prepare that stipulation in order?
I would.
Thank you.
Thank you,
Okay,
Judge.
so Mr. Dickerson, you are all set for today. You can go ahead and log out. Okay, Mr. Daly, do you have Mr. Duff with you?
Judge, I have a note on the docket that Mr. Duff waived arraignment.
Oh, I'm sorry, I missed that. Thank you.
Mr. Duff's waived arraignment, Your Honor, but I do have Mr. Maples.
Okay, we have called for him I do have a jail Zoom 3 device. If there's someone in that Zoom pod, we need you to turn the camera on and unmute the device.
Your Honor, I don't even know whether we need Mr. Maples today. We do not have the forensic report back yet on criminal responsibility until we get that.
I beg to differ. I think we do have that. Unless, are we waiting for an independent? No, I don't think so.
Yeah, I have a copy of that at least. I don't know when I received it, but there is I do have a copy of a letter dated April 29th dealing with criminal responsibility.
I will check on that today, Your Honor. Then we're ready to set this for trial and pending what the report says. I'll ask for an independent evaluation. I don't know.
All right, let me take care of Mr. Clark's case real quick here first. So. Okay, so this is file 24-21804-FH, People versus Larry Dean Clark. We are here today for a pretrial conference in this case, as well as a contempt of court for alleged failure to appear on May 7th. We are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
John Glazier on behalf of Mr. Clark. Your Honor, I think the contempt of court is for missing on May 1st is what I've got. That May 7th.
What? We don't have it?
Yeah, you are correct. It's May 1st. So where do we stand, or how does Mr. Clark want to proceed today, Mr. Glazier?
Your Honor, he was offered a possession of cocaine, which would be a 4-year felony. And they would dismiss the possession of meth and habitual offender. And he'll plead to that, and he'll also plead to the contempt of court, Your Honor. He would like to address bond when we're done, explain to you why he didn't show up on the first. I told him it'd be completely up to you. He was on a PR bond, but obviously the contempt of court stopped that, ended that.
All right, I'm going to need an amended information for that plea then.
Yeah, 1 second. Okay. All right, we're just gonna have to put this at the end of the docket too. I don't have a plea agreement or an amended information, so we'll get those.
All right, Mr. Clark, I'm going to put your device back in the waiting room, and when we have what we need, we will bring you back in and proceed. Let's do Maples then. So we're on the record in file 23-21397-FC, People versus Stephen Maples. We're here today for a pretrial conference. In this case, we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Arnold?
Allison Arnold for the people.
You'll need to unmute Mr. Daly.
James Daly for the people, or for the defendant, Your Honor.
All right, and you have Mr. Maples here by video conference from the jail. So, Mr. Daly, where do we stand with Mr. Maples' case today?
Yeah, no, I have had a chance to review the report from the Forensic Center. Based upon that report, we will be asking for an independent psychiatric evaluation.
All right, Ms. Arnold, anything to address from the people's side?
Oh, sorry. I don't know why my video is not going. No, thank you, Your Honor. There we go.
All right, Ms. Arnold, any issue with the appointment of an independent psychological evaluation?
No, I don't believe it's up to us to weigh in on that, but we have no objection.
All right. All right, then at this point, I will do an order for an independent psychological evaluation. Why don't we set this for another pretrial? Let's go with. Let's go June 26th and see where we stand with it at that point.
What day is that?
June 26th.
Thank you.
Mr. Daly, could you do that stipulation in order?
Yes, Your Honor. What time is
All
that,
right.
Judge?
8:15.
Thank you.
Okay, Mr. Maples, you can let the officer that's with you know that you're done with court for today.
Yes, Your Honor. Thank you.
Thank you. All right, Ms. Underwood, are you ready to proceed with Mr. Collar?
I am, Your Honor.
All right, Mr. Collar, you want to come forward, please? This is file 24-21823-FH, People versus Brian Cody Collar. We are here today this is scheduled for an arraignment today. We are proceeding today partially in person and partially by Zoom. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
Rhonda Underwood for Mr. Collar, Your Honor.
All right, and Ms. Underwood, does Mr. Collar wish to have the information read?
We would waive the reading of the information, acknowledge its receipt and the receipt of the witness list and request for discovery, Your Honor. In this matter, I believe Ms. Wagner has prepared and amended, Your Honor, to an added count of an attempted resisting and obstructing a one-year misdemeanor, and Mr. Collar wishes to plead to that with the understanding that the original felony and the subs are being dismissed, Your Honor.
Okay, I do have an amended information. Ms. Arnold, was that a complete and accurate statement of the plea agreement?
It is, Your Honor.
Okay, I would note on that amended information, there just appears to be a typo with respect to the penalty. It does say 2 years under the attempted. I believe that should be a 1.
Yeah, 1 year and or $1,000 fine, I believe.
Yes.
Make that correction myself. Okay, so Mr. Collar, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Brian Cody Collar.
Yes, sir.
Mr. Collar, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2 on the amended complaint, attempted assaulting, resisting, or obstructing a police officer?
Yes, sir.
You understand that the maximum possible penalty for that offense is up to 1 year in jail and or a $2,000 fine.
Yes, sir.
Are you satisfied with Ms. Underwood and the advice that she's given?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Arnold?
Correct, Your Honor.
Ms. Underwood?
Correct, John.
Is that also your understanding, Mr. Collar?
Yes, sir.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You can ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you're guilty, and you do not have to prove anything. You have the right to be present at trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent at your trial and not have that silence used against you. However, you also have the right to testify if you wanted to testify. Do you understand, Mr. Collar, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
Do you understand that you're giving those rights up?
Yes, sir.
How do you wish to plead to the charge that on or about April 21st, 2024 in the city of Adrian, County of Lenawee, that you did commit the offense of assaulting, resisting, obstructing a police officer? I'm sorry.
Sorry.
The charges that you attempted assaulting, resisting, obstructing police officers.
Guilty, sir.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, sir.
Do you understand that if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Collar to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Collar, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, sir.
Is it your own choice to plead guilty today?
Yes, sir.
Ms. Underwood, do you want to establish the factual basis?
Thank you, Your Honor. Mr. Collar, on or about April 21st, 2024, were you in the city of Adrian, County of Lenawee, state of Michigan?
Yes, ma'am.
And at that time, did you come in contact with Sergeant Adrian Robinson of the Adrian Police Department?
Yes, ma'am.
Was Sergeant Robinson in full uniform?
Yes, ma'am.
And you knew he was a policeman?
Yes, ma'am.
And at that time, did you assault, batter, or attempt to assault, batter, wound, resist, obstruct, oppose, or endanger Sergeant Robinson?
Yes, ma'am.
What did you do?
He was trying to handcuff me and I pulled my hands apart a little bit.
Okay. You physically resisted him?
I attempted to.
Yes,
yeah.
thank you. And he was doing his duty as a policeman, correct?
Yes, ma'am.
I believe that that's been established, Your Honor.
All
We're
right,
satisfied.
Ms. Arnold,
We're
I'm sorry.
satisfied. We're satisfied, Your Honor. Sorry.
Has the court complied with MCR 6.302 B, C, and D, then Ms. Arnold?
Yes, thank you.
Ms. Underwood?
Yes.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Collars had full knowledge of his rights. He had competent counsel. Court's made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, defendant, defense attorney, or anyone acting in the interest of any of them. I will refer this matter to, let's see, this is a misdemeanor, so I'll refer this matter to the District Court Probation Office for a pre-sentence investigation. Mr. Collar, you'll need to report to the District Court Probation Office on the first floor this coming Tuesday at 8 a.m. to do your pre-sentence investigation interview. Speak to Mr. McCarron about setting that up. Okay?
Yep. Yes, sir.
All right. And we'll set the sentencing date for June 21st at 8:15 a.m. Okay, so you're all set for today, Mr. Collar. Just make sure you report to the District Court Probation Office on Tuesday at 8 a.m.
Thank you, Your Honor.
Okay. Okay, and Ms. Underwood, I think they need you in Judge Anzalon's court.
I believe I'm done.
Somebody from Washington, so if you get
Yep.
over there, thanks.
Thank you.
Okay, is Ms. Hoops and Ms. Pawson here? Okay, please sit at the table closest to the jury box. This is file 24-51606-PH. Jessica Lynn Hoops versus Janessa Lene Pawson. We are here today for a hearing on an order to show cause alleging a violation of a personal protection order. Miss, you are Jessica Lynn Hoops.
Yes.
Looking at the file, Ms. Hoops, I don't see proof of service indicating that the order to show cause was served on Ms. Pawson.
Yes, they're having a very difficult time serving her. It was suggested that, can't remember what I was supposed to ask for, but it's like another way of serving her.
Okay, so there's a written motion that you need to file called a motion for alternate service. I think they can get you a copy of that across the phone in the clerk's office, or it's available online.
Okay.
But it's a motion for alternate service. If you're having a process server do it, there's a portion for them to fill out, just saying what they tried to do. So what I'll do is adjourn this to June 12th at 8:15 a.m. And in the meantime, you'll have to get that motion filed. There's no need for a hearing on that. and then go about the process.
Okay.
Okay. Okay, Mr. Glazer, I think we have everything we need for Mr. Peck.
Your Honor, Mr. Peck left. He's on his way back. I don't know if they went where they went, but Leo, they're not out there, right, Leo?
Yeah, they're not out here yet.
They're not out here yet. He talked to him about what, 10 minutes ago?
I don't know about that long.
He
Maybe
talked
like
to
5.
maybe 5 minutes ago, and they're on their way back. I don't know where they're on their way back from. When she asked me, I said it would be about 20 minutes, and I'm sure we've been longer than 20 minutes. I thought they'd be back by now. But when he is here, I'll let you know, and we're ready to do the plea. We got everything.
Okay.
Could we push Paul the room, please? Thank you.
Yeah, we won't have it. You know, because once it's conflicted out, we'll have to see that.
Come on back. Mr. Peck's coming back right now, Judge.
Okay, we are on the record now in file 24-21732-FH, People versus Alexander Peck. We are again here today for a pretrial conference. I do now have an amended information that was prepared today. So are we ready to proceed with entry of the plea?
Yes,
Yes, Your Honor.
Okay. And so let me just have Mr. Glazer once more state for the record what that is going to be, and then I'll have Ms. Arnold confirm.
Yeah, Your Honor, the original offer, and the one is changed just a tiny bit. The original offer was he was going to plead to CCW, or use of cocaine, which is a 1-year misdemeanor, and then a city resisting and opposing. We've changed that. It doesn't make any difference really. Instead of the city resisting and opposing, he's going to plead to a state disturbing the peace. So it'll be 1 felony, a 1-year misdemeanor, a 93-day misdemeanor, and he would get HIDA, Holmes Youthful Trainee Act status on those. I've explained to him that means if he does the Holmes Youthful Trainee Act, the probation, that would go off his record. So it's very important that he, fulfill the terms of probation so these criminal charges don't enter on his record. Is that correct, Mr. Peck?
Yes, sir.
And that's what you want to do here today?
Yes, sir.
Did you hear that, Your Honor?
I was not able to hear Mr. Peck,
Speak up.
Yes, sir. Yes, sir. Your Honor.
All right.
For the record,
All
he
right.
is saying yes to all the questions I asked. He that is the plea, and he wants to do that today. Is that correct?
Yes,
Real
sir.
loud.
Yes, sir. Yes, Your Honor.
Okay, Ms. Arnold, is that a complete and accurate statement of the agreement?
It is, other than the defendant shall forfeit any weapon that was seized.
Yeah, that was too, Your Honor. I forgot about that, but he knows he's not getting the gun back that was recovered.
All right, Mr. Peck, can I have you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Alexander Dominic Peck?
No, my name, I don't have Alexander in my name, Your Honor.
I'm sorry, I misread that. It's just Alex Dominic Peck.
Yes, yeah. Yes, sir.
Okay. And Mr. Peck, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, carrying a concealed weapon?
Yes, sir. Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 5 years in prison or a $2,500 fine?
Yes, Your Honor.
You can put your hand down if you want. Is it also your intention to plead guilty today to count 5 on the amended information, use of cocaine?
Yes, sir. Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 1 year in jail and or a $2,000 fine?
Yes, Your Honor.
And is it also your intention to plead guilty today to count 6 on the amended information, disturbing the peace?
Yes, Your Honor.
And you understand the maximum possible penalty for that offense is up to 90 days in jail and or a $500 fine?
Yes, Your Honor.
Do you understand that the carrying a concealed weapon charge comes with a mandatory forfeiture of that weapon or device?
Yes, Your Honor.
Are you satisfied with Mr. Glazer and the advice he's given you?
Yes, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Arnold? Other than as we've discussed it here today, is that correct, Ms. Arnold?
Yes, Your Honor.
Mr. Glazer.
That's correct, Your Honor.
Is that also your understanding, Mr. Peck?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Peck, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
Do you understand that you're giving those rights up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about January 28, 2024 in the city of Adrian, County of Lenawee, that you did commit the offense of carrying a concealed weapon?
Guilty, Your Honor.
And how do you wish to plead to the charge that on or about January 28, 2024 in the city of Adrian, County of Lenawee, that you did commit the offense of use of cocaine?
Guilty, Your Honor.
And how do you wish to plead to the charge that on or about January 28, 2024 in the city of Adrian, County of Lenawee, that you did commit the offense of disturbing the peace?
Guilty, Your Honor.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No, Your Honor.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your pleas were given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Peck to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Peck, other than as we've discussed on the record today, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, Your Honor.
Is it your own choice to plead guilty today?
Yes, Your Honor.
Mr. Glazer, do you want to establish a factual basis?
Yeah, Mr. Peck, on January 28th of 2024, you were here in Lenawee County in the state of Michigan. Is that correct?
Yes, sir.
And you were here in Adrian, and you were actually sleeping in your car near the Planet Fitness out there in the parking lot, I believe. Is that correct?
Yeah.
And at that time, the police came because there had been a call about a car running with the lights on. And the police came into contact with you while you were in that car. Is that correct?
Yes, sir.
And you were asleep.
I need Mr. Peck to speak louder.
Yes, sir. My bad. I'm sorry.
All right. And you were asleep in the back seat of the car. Is that right?
Yes.
All right. When the officers at some point got you out of the car, is that true?
Yeah.
And at that time, you had in the vehicle a pistol. Is that correct?
Yes.
And you didn't have.
I can't hear Mr. Peck. Mr. Peck, I need you to, it helps if you look directly at the device and speak louder than you think you need to.
Yes, Your Honor.
Okay, thank you.
All right. And you had a pistol in there in that car. Is that correct?
Yes, Your Honor.
And you didn't have a CCW permit or a license to carry that in the vehicle. Is that true?
No.
Is that true?
Yes, it's true. Yes, it's true.
All right. There was also some cocaine found in the car, and I don't know if you're using it that day, but you had used it on or about that date. Is that correct?
Yes, sir.
And during that time, there was I think the police tried to arrest you, and you pulled back your arms, and there was a little bit of a disturbance. Is that correct?
Yes, sir.
And you're going to admit that action caused a disturbance in a public place, disturbing the public peace. Is that correct?
Yes, sir.
Yes,
Yes, sir.
And I've explained to you that the agreement is for HIDA. You understand the judge gives you the HIDA probation, and you violate your probation, they could kick you off that, and these convictions would stick and be on your record. You understand that?
Yes, sir.
So it's very important you complete your probation. You understand that?
Yes, I understand.
Okay. I don't have any other questions, Your Honor.
Ms. Arla, are the people satisfied with the factual basis?
We are.
Court complied with MCR 6.302 B, C, and D. Ms. Arnold?
Yes, Your Honor.
Mr. Glazer?
Yes, it has, Your Honor.
All right, I will accept the pleas then. They've been given understandably, voluntarily, and accurately. The defendant has had full knowledge of his rights. He's had competent counsel. The court's not made any agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for June 27th at 8:15 a.m. Mr. Peck, when you do your pre-sentence investigation interview, please be truthful about these offenses and about your background.
Yes, Your Honor.
Judge, we have a quick breakout room to get his address.
Yeah, 1 second. And Mr. Glazer, you said he was going to plead to the contempt as well?
Yeah, what was the, for that showing up? Or is that a different case?
That was let me look at it. Pretty sure
I don't remember there being a contempt of court on this one. Let me look. You think there is? Yeah, I do show a contempt of court on the, but I don't know what it was. What would you not show up at a hearing or something?
I think it was the one.
Yeah, it's a failure to appear.
Okay, yeah, he'll plead to that contempt of court, Your Honor.
All right, Mr. Peck, you understand that with respect to the contempt of court for failure to appear, you also have a right to trial on that.
Yes, Your Honor.
And you understand that you would be presumed innocent at that trial until your guilt was proven beyond a reasonable doubt.
Yes, Your Honor.
You understand that you'd have all the same rights that I've already described to you at the contempt trial as you did with respect to the other charges that you pled to today.
Yes, Your Honor.
And that would include the right to have the witnesses against you appear at your trial. You could ask them questions. You have the right to remain silent at your trial if you wanted to. You could also testify if you wanted to testify. Do you understand all of that?
Yes, Your Honor.
You'd also have the right to have Mr. Glazer, your lawyer's assistance at that trial if you wanted that. You understand that as well?
Yes, Your Honor.
All right, so how do you want to plead then to the charge or to the contempt of court?
Guilty, Your Honor.
Has anything been promised to you in order to get you to plead guilty to that?
No, Your Honor.
Has anybody threatened you in any way?
No, Your Honor.
You understand if I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court today?
Yes, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
All right, so there was a pre-trial in this case scheduled for March 27th, 2024. Is that correct?
Your Honor, I don't know. Is that correct? Were you supposed to be here on March 27th? I don't have it in my notes, but probably somebody else from my office handled it. There's a contempt is for not showing up.
April 16th was my last court date that I remember.
That's down in district court. You're saying he had one on the 27th he didn't show up for, Your Honor?
Yeah, and looking at the court file, he waived arraignment. We sent a notice of a pretrial for March 27th, and that was the date that generated the warrant.
Yeah, you agree you weren't here on the 27th?
Yes, I agree.
He agrees he wasn't here on the 27th, Your Honor. I don't, it's not in my file, but that doesn't mean somebody else didn't handle it for me, and it wouldn't be reflected in my file. It'd be reflected on our computer. But he doesn't dispute that, Your Honor.
All right, I'll accept the plea then. It's been given understandably, voluntarily, and accurately. I will set sentencing for the same date as on the underlying file.
Okay,
So, Mr. Glazer, I'm gonna put you and Mr. Peck in a breakout session so that Mr. Peck can give his contact information to the probation department.
all right, I'll be back after we do that breakout, Your Honor.
Okay. And Mr. Paulding, I'm gonna put you in a breakout session with Mr. Malaro, if you give me just a second here.
Your Honor,
Yeah,
Mr. Peck's got a misdemeanor. I want to check and see what happened with that. Then I'll get right back. It's okay.
okay.
All right, thanks.
Okay, Mr. Malaro, are you ready to proceed with Mr. Paulding?
I am, Your Honor.
Okay, we are on the record in file 23-21326-FH and 23-21449-FH, People versus Bush Lee Paulding. We are here today for pretrial conferences in both of those cases. And we're proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Arnold?
Allison Arnold for the people.
Salvatore Malero on behalf of Bush Paulding.
All right, and Mr. Malero, where do we stand with Mr. Paulding's cases today?
Your Honor, where we stand is I'm going to ask to adjourn this one time. I am in the process of trying to find common ground with Miss Arnold. I've spoken to the detective on one of these cases to see if we could get some things resolved. And so that's the basis for my request.
All right, Ms. Arnold, anything that you want to address from the people's side?
No, thank you. I think a short adjournment is appropriate. We can figure it out in probably 2.
I agree with that.
Sorry, you kind of cut out. Did you say 2 weeks?
2 weeks, yeah.
Yeah, 2 weeks is fine, Judge.
Okay, so 2 weeks would be June 5th. So let's do June 5th at 8:15.
Thank you, Judge.
Mr. Malero, would you do that stipulation in order?
I will.
Okay. Thank you then. I think we're all set. Mr. Paulding, you can let the officer with you know you're done with court for today.
Okay, thank you.
Thank you, Judge. Thank you, Miss Arnold.
Yeah.
All right, Mr. Clark, we've got the documents we need now, but Mr. Glazier had to step away, so as soon as he gets back, we'll proceed with your case.
All right, thank you, Your Honor.
If you want to call.
Your Honor?
Yes.
I'm reasonably certain I have no further cases before you today. May I take my leave?
Yep, we are all set. Thank you.
Thank you, Judge.
All right, thank you. All right, bye.
Okay, I have the amended information for Mr. Clark, so I think we can proceed there.
Is there any way I
Back on
can
the
speak to my attorney again, Your Honor?
Yeah, 1 second. What case were you? Yeah, that was the first one that we did this morning. Thing. July 17th at 8:15 is his next date.
Was adjourned until July.
Yeah. He's filing what they call an interlocutory appeal. That means an appeal while the case is going on. So we're hoping that the appeal will be resolved by that time.
So does my daughter's the victim.
If you have issues with respect to your daughter, you should contact the victim's rights advocates in the prosecutor's office.
Based on July 17th?
July 17th.
All right.
Okay, we're back on the record in file 24-21804-FH, People versus Larry Dean Clark. I do now have the amended information. Mr. Glazier, are we ready to proceed?
Your Honor, yeah, we're ready to proceed.
All right, and the plea again is going to be to count 2, the possession.
Your Honor, in talking with Mr. Clark, he does not want to avail himself of the plea and he wants to set this for a trial. I've explained to him that the offer is a possession of cocaine, which is a 4-year max with no habitual offender on it. I don't know what the guidelines are, but I'm sure it's jail and not prison. He does not want to take advantage of that plea. He wants to set it for trial. I've explained to him and he understands that what he's charged with is possession of meth, a 10-year felony with 3 prior felonies, making it a habitual 4, which carries life, which is, it's a big difference between that and a 4-year. But I just want to put on the record that he's been explained what that situation is, and he wants to set it for trial.
And Judge, just to add to that, we did offer sentencing under Michigan Compiled Law 333.7411 if the defendant is eligible, which means court would hold the plea in abeyance if he's eligible, and if he successfully completes probation, he would not have a conviction for this offense.
I don't know what that statute is you're citing.
It's 7411.
Oh, 7411?
Was offered if he's eligible.
I don't remember if you understand that, Mr. Clark?
Am I eligible for it, sir?
I don't know. Do you got prior drug charges?
No, I don't. Well, I have, I don't know if it's still on my record, but it was conviction in district court for possession of cocaine, but it was not cocaine. It was a marijuana joint. But for some reason, they charged me as cocaine in district court. But as far as I know, that should be removed from my record because it's marijuana.
I don't see anything on his record, but if that makes a difference, Mr. Clark, I can adjourn this and I can look into that.
It certainly does. It certainly does, sir.
Well, my question is if they add on to it that you're going to get 7411, which means it goes off, this plea would, or this conviction would go off your record upon completion of the probation. Are you willing, does that change it? Do you want to take the plea?
Oh yeah, for sure, for sure.
All right. I need to look into that. I'm not even sure that you can't get a 7411 with a prior conviction anyway. I haven't looked at that statute in a while, but I'm thinking the last I looked at it, it didn't matter if you had a prior conviction. I guess it was up to the court if it was going to grant it. So maybe if I could have a week to look that over.
Yeah, I can set that over for next week, May 29th at 8:15. Would you do a stip in order for that, Mr. Glazer?
Yeah. Your Honor, could I address bond while we're on it?
Yeah, go ahead.
Mr. Clark was out on a PR bond, Your Honor, and he didn't show up on May 1st. Rather than me explain what happened, I would rather have him explain, but we'd ask the court to consider giving him the PR bond back. But I told him it's obviously up to you. Mr. Clark, if the court's okay, could he explain to you why he didn't show up on the 1st?
Yes,
Yeah, go ahead.
I had came in to the probation department with full intention to get my my color card because they had me placed me on colors. And I came in, got it. As soon as I had left, I ran into my ex-girlfriend, and I believe she had stolen my wallet. So I didn't have no ID or my color card I just received. All that is all gone. I do have the ways and the means to get it. I have a photo on my phone now of my driver's license. So I'm allowed to go to the Secretary of State where they can provide me with the new I got to get it updated anyway because my birthday was the 20th of this month. So I can go ahead and get my ID again. But I had no way of doing nothing. Like as soon as I got it, I had $120, my ID.
So why didn't you show up on the 1st, Mr. Clark? That's my question.
Well, that was the issue. I just didn't have no ways or means, and I pretty much knew I was going to jail.
Oh, for not testing, you mean?
Yeah.
Okay.
Yeah. But yeah, I'm solely responsible for everything I have out there. I have had stuff come up missing in the past. It's probably already been ran through a couple times by now. But I just like to get out there and take care of my dogs, do what I have to do. And I wasn't trying to avoid nobody. Like
Well, you just said you didn't show up because you thought you were going to go to jail. That's avoiding.
Well, I mean,
that's
I understand that, Your Honor, but I mean, it wasn't like I changed my daily schedule because I do things like I was always inside of the police. I mean, I wasn't in hiding or nothing like that. Like my routine was still the same thing as far as like how I profit to make money. You know, like the police always see me on like a daily basis. I not in a bad way, you know. I pretty much can and dumpster dive as a ways and means, and I'm always in view, you know what I mean? Like I'm not trying to hide. But yeah, I really need to get to my dogs.
all right. Ms. Arnold, people wish to have any input?
Judge, I think you have two issues here. One, he didn't do the drug testing, and two, he didn't appear because he was afraid of going to jail, which I kind of understand. But I think with him having a drug problem, release into some sort of treatment, or if there are conditions to assure he's testing and complying with treatment, if we can assure that, we wouldn't oppose a PR bond, but I guess we would just defer to the court.
Well, I can assure you, as soon as I get out, I can go to the Secretary of State. My sister said she would pay for my new ID, so I can get my new ID now. And I have the photo, which before you weren't allowed to do that. Now all you have to have is a photo of yourself on your of your driver's license, front and back, and then the Secretary of State will allow you to get the new ID, and they will allow me to do that.
Your Honor, I think what he's trying to describe is he can't test without an ID. He'd lost his ID, and they won't allow you to test unless you have a photo ID. I think
Right.
that,
And I had full
I
intention
think
to.
that's what the roundabout of what he's
Yeah.
trying to explain to the court.
Yes, Your Honor. And like I said, I had just went into the probation department that day and requested the color card for the drop. So I had everything, the ways and means to proceed, and then I just don't know what happened to my wall. And trust me, it's so hard. This is like, it becomes a nuisance after so many times, you know, like just losing your wallet is just a whole life changer in itself. I also, if I must say, I went to court for contempt in district court on the same day as I seen you last time, and I have the financial obligation to pay off my fines downstairs by June 7th, or else they'll hold me in contempt down there too, which I would really like the opportunity to be able to pay off the $400 and rather than get more jail time.
All right, so Mr. Clark, I'm going to reinstate the PR bond at this point. You need to understand that you need to comply with every single provision from this point forward.
Understand, Your
And any violation of the conditions of your bond is going to result in me issuing another warrant and then not listening to further promises that you're going to comply in the future, because you had a contempt of court in district court for not testing. You got credit for time served on that, and then you didn't appear and you weren't testing up here. So a single missed test is going to be a warrant, and we're done with the PR bonds at that point.
Totally understood, Your Honor.
So I'll reinstate your personal recognizance bond. You need to report to Darren Coast in Circuit Court Pretrial Services as soon as you're released from jail. So if it's today, before 4 o'clock, you need to come directly over to the courthouse and talk to Mr. Coast. If it's after 4 o'clock, you need to be here at 8 a.m. tomorrow morning to talk to Mr. Coast.
Right. Thank you, Your Honor.
Mr.
You
Clark,
must
you
not use
understand?
alcohol.
Yes, sir.
Must not use alcohol, marijuana, or any illegal substances. You must participate in drug testing as directed by Mr. Coast. You must participate in any drug treatment that he requires you to participate in. And that'll be it for your conditions. So I'm sorry, Mr. Glazer, you were trying to say something.
Yeah,
Mr.
yeah, Mr. Clark, write down that you gotta be back in court the 29th.
I'll have it. Yes, sir.
If you want to come over to my office and do it in person, we can Zoom from here, okay?
All right, that'll work.
Make sure you're here and, Oh, and also, Mr. Clark, why don't you come see me before, that's a week from Wednesday, week from tomorrow. But come and see me before that so we can talk this over and look at the
All right.
74
Sir,
level.
would you like to set up a time? Like,
Just when you get out, come over here and set up a time at our office.
All right, no problem. Thank you.
All right,
Mr.
I'll see you later, Mr. Clark.
Thank you.
All right, you're set then, Mr. Clark. You can let the officers know that you're done with court.
Thank you, Your Honor.
So we've called for Mr. Kennedy. We're just waiting for them to bring him to us.
Great, thank you so much.
Judge?
Yeah.
You're not going to believe this, but we'll correct it when it comes back for sentencing. When we did, I think it was Mr. Peck. I did the factual basis on the wrong file.
Oh.
I did it on the person we just had. So on Mr. Clark. So I'll straighten that out when we come back for sentencing, because the factual basis was off the completely wrong file.
Okay.
When I got reading Mr. Clark's, I said, man, it seems like I just heard this one. And then I realized the mistake I had made.
All right. I will make a note on our file for that then.
Yeah, I'll take care of it when he comes back.
Wait, I'm confused. Mr. Glazier said he put the wrong factual basis on for Peck.
I think so, yeah.
I don't think so, but I would.
Unless they're the same. I was just looking.
Peck has a carrying a concealed weapon.
Right, but I indicated he was at the Planet Fitness in the car. That's the wrong case.
Oh, I got it. Okay.
He just, I kept saying that was true and he just kept agreeing with me, which always
Okay.
surprises me, but I'll change it around to what it actually was.
Yeah, I think they could.
It's amazing. It is almost the same factual basis. He was in a vehicle with the headlights on and been on for several hours. So maybe we don't need to correct it other than that's
Okay.
kind of strange.
All right, I've stuck a note on my calendar to.
Yeah, I just want to clear it up, make sure I didn't mix the two up. They're very similar in nature.
Right, and yeah, we can go back and listen to the factual basis if we need to as well, so.
All right,
Are we ready to go then with Mr. Kennedy?
yeah, sure.
All right, we are back on the record in files 23-21426-FH, 23-21427-FH, 23-21578-FH, and 24-21803-FH. People versus Daniel Martez Kennedy. I do now have a copy of the written plea agreement. We have at this point, Ms. Hennigan had sent me a chat a few minutes ago. She had another hearing and had to leave the meeting. She indicated in that chat that she was comfortable with letting the plea go forward, given that Mr. Glazier was here. Mr. Glazier, do you have any issue with that?
Yeah, I guess I'd rather have her do it, Your Honor. The charges he's pleading to on her file are rather serious, and it's going to result in a Killebrew or Cobbs to prison. And I'd rather not, she's the one to talk to Mr. Kennedy about that, not me.
I did not, when she sent me that chat, realize that everything he's pleading to was in the files of Ms. Hennigan is handling, and Mr. Glazier's files being dismissed. So I can understand why you would.
Yeah, the charges he's pleading to are rather insignificant and are going to run concurrent. The serious charges are all the ones that Ms. Hennigan's handling.
Yeah, okay.
And he's had lots of discussion with her about that, not me.
Okay, so Mr. Kennedy, I'm going to put your device in the waiting room, and we'll try to contact Ms. Hennigan's office and see if she can get logged back in.
All right.
Okay. Okay, we have Ms. Hennigan back with us now. So we're back on the record in People versus Daniel Martez Kennedy. Again, I do have the written plea agreement at this point. So are we ready then to proceed forward with the plea?
Yes, Your Honor.
I am, Your Honor. I don't have the written plea agreement, but I assume it says plead to counts 2 and 3 without a habitual to run concurrent.
John, I will forward that to you right now.
What's that? Isaac, what?
I'll forward it to you right now. Isaac sent it to me.
Oh,
Just forward it.
All right, just so we're clear, the agreement that I have indicates that in file 23-21578-FH, Mr. Kennedy would plead to count 1, possession of a firearm by a felon, count 3, resisting and obstructing a police officer, count 4, resisting and obstructing a police officer, and count 6, malicious destruction of police property with a habitual offender third offense notice. In file 24-21803-FH, he would plead to count 2, resisting and obstructing a police officer causing injury, count 3, malicious destruction of property. There was a sentence agreement that Mr. Kennedy would serve no less than 48 to 90 months in the Michigan Department of Corrections, and all files would run concurrently. In files 23-21426-FH and 23-21427-FH, all files, all charges would be dismissed. In file 23-21578-FH, counts 2 and 5 would be dismissed, and the habitual offender fourth offense notice would be dismissed. In file 24-21803-FH, counts 1, 4, 5, 6, 7, and 8 would be dismissed, and the habitual offender fourth offense notice would be dismissed. It would also require the people to dismiss a district court case filed 23-2163-OM. So is that, I guess, let me start with Ms. Arnold, is that a complete statement of the plea agreement?
Yes, Your Honor. I saw the court caught the typo in paragraph 4 about dismissing file 21427-FH. If the court can just make that change on the original.
Okay, is that a complete and accurate statement of the plea with respect to your files, Ms. Hennigan?
Yes, it is with respect to my files, Your Honor.
And Mr. Glazier, is that a complete and accurate statement of the plea agreement with respect to the 24 file? You are muted, Mr. Glazier.
I believe it is, Your Honor. I don't have a copy of that plea agreement, but it's my understanding, I've got the old one, and what it's supposed to be is he's pleading guilty to count 2 and count 3, with the understanding that all their charges will be dismissed, and those will run concurrent to Ms. Hennigan's files.
That is what it says, Mr. Glazier.
Yeah, I believe in hearing it, that was right, but I'm not looking at the new plea agreement. I'm looking at an old one.
All right. Mr. Kennedy, would you raise your right hand then?
I'm in the hole, so I'm really.
Okay, so just, yeah, I can kind of see it raised there in the bottom corner of the screen. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yeah.
And you are Daniel Martez Kennedy?
Yeah.
Mr. Kennedy, you've heard the statement of your attorneys and the prosecuting attorney. Is it your intention to plead guilty in file 23-21578-FH to count 1, possession of a firearm by a felon?
Yes.
Do you understand the maximum possible penalty for that offense is up to 5 years in prison and or a $5,000 fine?
Yes.
Is it also your intention to plead guilty to count 3, assaulting, resisting, obstructing a police officer?
Yes.
And you understand the maximum possible penalty with respect to that offense is up to 2 years in prison and or a $2,000 fine?
Yes.
And is it also your intention in that file to plead guilty to count 4, another count of assaulting, resisting, obstructing a police officer?
Yes.
And you understand again the maximum possible penalty for that offense is 2 years in prison and or a $2,000 fine?
Yes.
Is it also your intention to plead guilty in that file to count 6, malicious destruction of fire or police property?
Yes.
And do you understand the maximum possible penalty with respect to that offense is up to 4 years in prison and or a $5,000 fine?
Yes.
Is it also your intention to plead guilty or admit to the habitual offender 3rd offense notice?
Yeah.
Do you understand that that changes the maximum possible penalties that I just described to you?
Yeah.
Do you understand that with respect to count 1, then the possession of firearm by a felon file, then the maximum possible penalty would be with the 3rd. Okay, so the plea agreement says that he's pleading to a 3rd offense supplement, but the information has a 4th offense notice on it.
Right, we wouldn't. I don't think, well, at least to my knowledge, we didn't customarily change the habitual offender 4th offense notice. He just pleaded to, admitted to 2 of the offenses. If the court wants an amended information with the 3rd offense notice and a 4th offense notice, we could do that.
Just give me a second.
We could put on the record, or should, that the offenses are doubled on all the underlying offenses with the habitual offender 3rd offense notice.
So Mr. Canning, do you understand that with respect to the possession of firearm by a felon charge, I had previously said to you that the maximum possible penalty would be up to 5 years in prison. Because of the habitual offender, the maximum possible penalty would be up to 10 years in prison.
Yeah.
And with respect to the 2 assaulting, resisting, obstructing a police officer charge, the maximum possible penalty would be up to 4 years in prison rather than the 2 years in prison that I previously indicated.
Yeah.
And with respect to the malicious destruction of police property charge, the maximum possible penalty would be up to 8 years in prison rather than the 4 years that I previously stated.
Yeah.
Your Honor, I'm looking up that statute really quickly because I thought a third offender was 50% increase and a fourth offender was double, but I'm reading the statute really quickly to verify.
The second is 1.5 times, a third doubles it, and a fourth is life if the primary offense has a penalty of 5 years or more, or 15 years if the primary offense has a penalty under 5 years. It's
769.11. I don't know, Ms. Hennigan, if you said something, you're muted. I wasn't able to hear it.
That was the one I was reading. I'm fine, Your Honor. I just wanted to double check.
Okay. All right, so in file 24-21803-FH, Mr. Kennedy, is it your intent to plead guilty to count 2, assaulting, resisting, obstructing a police officer causing injury?
That's on my file, Mr. Kennedy. Is it your intent to plead guilty to that?
Yeah.
All right, you understand the maximum possible penalty for that offense is up to 4 years in prison and or a $5,000 fine.
Yeah.
Is it also your intention to plead guilty in that file to count 3, malicious destruction of fire or police property?
Yeah.
And you understand, since this file does not have the habitual offender, that the maximum possible penalty for that offense is up to 4 years in prison and or a $5,000 fine.
Yes.
All right, are you satisfied with Ms. Hennigan and Mr. Glazier and the advice that they have given you?
Yes.
Other than, as we've discussed it on the record here today, neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Arnold?
That's correct, Your Honor.
Ms. Hennigan?
That is correct, Your Honor.
Mr. Glazier?
That's correct, Your Honor.
Is that also your understanding, Mr. Kennedy?
I didn't hear what you asked him.
So I asked them that other than as we've discussed it on the record here today, neither you, your attorneys, or anyone from the prosecutor's office has discussed a possible sentence with me.
Oh, yeah.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you're guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Kennedy, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
Do you understand that you're giving those rights up?
Yeah.
How do you wish to plead then in file 23-21578-FH to the charge that on or about October 1st, 2023, in the city of Adrian, County of Illinois, that you did commit the offense of possession of a firearm by a felon?
Guilty.
And how do you want to plead to the charge that on that same date in the same location, you commit the offense of assaulting, resisting, obstructing a police officer, count 3?
Guilty.
And how do you wish to plead in that file that to the charge that on or about the same date and in the same location, you did commit the offense of count 4, assaulting, resisting, obstructing a police officer?
Guilty.
And how do you wish to plead to the charge that on or about, again, October 1st, 2023, in the city of Adrian, County of Lenawee, you did commit the offense of malicious destruction of fire or personal property?
Guilty.
In file 24-21803-FH, how do you plead to the charge that on or about March 14, 2024, in the city of Adrian, County of Lenawee, that you did commit the offense of assaulting, resisting, obstructing a police officer, causing injury?
Guilty.
And how do you wish to plead in that file to the charge that on or about March 14, 2024, in the city of Adrian, County of Lenawee, you did commit the offense of malicious destruction of fire or police property?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to any of those charges?
No.
Do you understand that if I accept your pleas, you'll be giving up any and all claims that your pleas were given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter those pleas?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Kennedy to plead guilty?
No, Your Honor.
No, Your Honor.
No, Your Honor.
Mr. Kennedy, other than as we've discussed it on the record this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty today?
Yeah.
All right, Ms. Hennigan, do you want to cover the factual basis with respect to your file?
Ms. Arnold, would you be okay with covering that? I do not see my police report for that particular file. Right?
I could, but I have not read the police report yet since it's Isaac's case, so it's going to take me a minute.
One moment.
While she's reading it, Your Honor, I put on the factual basis for mine.
Okay, yeah, so we can go with Mr. Glazer's file first. So, Mr. Glazer, you can go ahead.
Yeah, Mr. Kennedy, you understand I represent you on a file that had 6, or did it have more now? Let me see, 8 different counts. Is that correct?
Yes.
And you have entered a plea of guilty to resisting and opposing a police officer causing injury and malicious destruction of fire or police property. Is that correct?
Yes.
The information says that on March 14th of this year, that you came into contact with the police department. Is that correct?
Yes.
And what was that? They picking you up for a violation of a bond condition or something?
Yes.
All right. And in the course of that, there was some resistance. You struggled or fought with the police. Is that correct?
Yeah.
And also during that time, there was a handcuff case that belonged to one of the officers that got damaged. Is that correct?
Yeah.
In regards to the R&O, there was a list. You probably didn't know her name, but you would agree that there was an Alyssa Monette from the APD there, a female. Is that right?
Yeah.
And you've seen the report. You know she received some type of injury that required her to go up to the hospital. You understand that?
Yeah.
And we agree with that. Is that correct?
Yeah.
All right. I don't have any other questions, Your Honor.
All right, Ms. Arnold, are the people satisfied with the factual basis as to the 24-21803 file?
We are, Your Honor.
All right, and Ms. Hennigan, were you able to find your copy of the police report, or do you need Ms. Arnold to do that?
Nope, I'm ready, Your Honor.
Okay, go ahead.
Mr. Kennedy, on or about October 1st of 2023, were you in the city of Adrian, County of Lenawee?
Yeah.
Do you recall coming into contact with Officer Monet and Officer Bear that day?
Yeah,
And at that time, did they attempt to take you into custody?
yeah,
Was there a struggle between you and the officers?
yeah,
At that time, did they also search the vehicle that you had been in and find a firearm?
yeah,
Do you agree that prior to that date, October 1st, 2023, you had been convicted of a felony?
yeah,
And do you agree that because of that conviction, you were ineligible to have possession of a firearm?
yeah,
And once you were placed to the police vehicle, that there was damage caused to the window of the vehicle,
yeah,
and were you the one that caused that damage?
yeah.
Thank you. Is that satisfactory to Ms. Arnold?
I just have a couple questions, just to make it clear.
Sure.
Mr. Kennedy, you possessed that firearm found in the car, correct?
Yeah,
Okay. And you knew the officers, Officer Monette and Officer Bear, were police officers. They were in fully marked uniform and they were acting in lawful performance of their duties. Is that correct?
yeah,
Okay, I'm satisfied.
All right, Mr. Kennedy, do you agree that you were previously convicted on June 2nd, 2017 of possession of cocaine, heroin, or another narcotic less than 25 grams in the Third Circuit Court in Wayne County, Michigan?
yes,
Do you also agree that you were convicted on or about February 2nd, 2018 of delivery or manufacture of cocaine, heroin, or another narcotic of less than 50 grams, also in the Third Circuit Court for Wayne County, State of Michigan?
yeah,
All right. Has the court complied with MCR 6.302 B, C, and D, Ms. Arnold?
Yes, Your Honor.
Ms. Hennigan?
Yes, Your Honor.
Mr. Glazier?
Yes, Your Honor.
All right, I will accept the pleas. They have been given understandably, voluntarily, and accurately. Mr. Kennedy's had full knowledge of his rights. He's had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as has been placed on the record here this morning. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for June 28th at 8:15 a.m.
Does Mr. Kennedy wish to be personally present for that?
Thank you. Mr. Kennedy, you have the right to be present in the courtroom in person for your sentencing hearing if you want to be. You can also do it by Zoom if you prefer that. If you want to do it by Zoom, you would have to waive your right to be here in person. Do you know which you would rather do?
I'll come in person.
Okay, so we will note our file that will be an in-person sentencing hearing for Mr. Kennedy on June 28th at 8:15 a.m. All right, so Ms. Kennedy, again, someone's going to be in touch with you from the probation department to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
All right.
Bond will be continued. So you're all set for today, Mr. Kennedy.
Judge Olsever, could I just ask one more thing, please?
Yeah, I'm sorry, go ahead.
Mr. Kennedy, can I have your permission to sign this plea agreement that you entered into today so I can send a signed copy over to the court?
Yeah,
I can sign on your behalf?
yeah.
Okay, thank you. Thank you, Your Honor.
Ms. Hannigan, just to note, I think in paragraph 4, we said file ending in 2/6, change the last one to 2/7.
I did make that correction and initial it before I send it over. Thank you.
Great. Thank you.
Okay, I think that's everything we had for today.
All right, I'm all set, Your Honor. I didn't have anything else. Thank you.
Thank you. Other than we've got that pickup to do.
Yeah.
We're ready to bring Mr. Bright in.
28.
You bring Mr. Bright. Yes. Proceed. All right, we are on the record in file 22-49466-DO, Tina Jean Bright versus Thomas William Bright Jr. We are here today for arraignment on bench warrant. Sir, you are Thomas William Bright Jr.
Yes.
Mr. Bright, have you received a copy of the warrant?
No, sir.
All right, just hang on a second. We'll get you a copy of that.
Can I speak, Your Honor?
I've got it. Before you speak, I will give you an opportunity to speak, but before you do that, I have to make a record of the fact that you know what your rights are.
Yes, sir.
So one of those rights is that you receive a copy of the warrant. So we're going to do that right now, and I'll ask you a few other questions, and then if you want to speak, I'll give you the opportunity to do that.
Yes, sure.
Ms. Bright, the bailiff is handing you a copy of the warrant. Take whatever time you need to read that and just let me know when you're finished.
Sure. What do I have a warrant for my arrest?
Okay, I just want you to read through it and let me know when you're finished.
Yeah, I'm finished.
Okay.
I've never had a warrant for my arrest in my life.
Sir, as I just said, before you speak, I have to ask you some questions to make sure that you understand what your rights are. And then if you want to speak, I'll give you that opportunity. But can you just let me do my job before you speak? Okay. The warrant alleges that you failed to appear in court for a hearing that we had scheduled in this case on May 13th, 2024. The maximum possible penalty for a contempt of court would be 93 days in jail or up to $7,500 in fines. You have the right to be represented by an attorney at this hearing today and at any other hearings that we have regarding this matter. If you can't afford an attorney, you can tell me that and I'll appoint one for you at public expense. Do you understand that?
Yes, sir.
Do you want to be represented by an attorney?
Yes, sir.
Okay. So the attorney that we have, well, do you have the ability to pay for your own attorney?
Your Honor, I've been ripped off for everything I have. I'm homeless.
I just need to know yes or no.
No, sir.
All right, so I'll appoint the public defender's office to represent you. Ms. Underwood is in the next courtroom handling some cases right now, so I'm gonna have them take you back to the holding area. And as soon as Ms. Underwood is free, I'll have her speak to you.
Yes, sir. Can I please speak on something, Your Honor?
You've asked to be represented by an attorney. So at this point, I'm gonna have you speak to your attorney. And then after you've spoken to her, if you want to speak to me, you can.
Yes, sir. Can I use the restroom? Yes.
All right, so Ms. Knies, I don't know if you want to wait there, or if you want us to give you a call when Rhonda's free.
If you could give me a call, that would be wonderful. Thank you, Your Honor.
Okay, we will do that.